In that particular alternate compliance, you suggested earlier tonight that there has to be a quasi-judicial hearing to determine that, correct?
Yes, and I think one of the real difficulties is that the alternate compliance requires that it be equal to or better than regular compliance. And it's difficult, it's difficult for me to say how the current configuration is equal to or better than the regular compliance. Folks have tried to make the best of a very difficult situation and try to figure how can we fit this 15 pounds into this 5-pound bag, and have done masterfully at trying, but you're left with that fundamental difficulty.
And the reality being that the loading dock for that building, in order for it to comply with a buffer between a commercial and residential properties, shouldn't really even be where it currently is today.
It was very difficult for me to see as a planner how you could do that. The practical reality is that's where it is. But yes.
I agree with Mr. Owens that the loading bays never qualified for grandfathering. That project that Maxwell Street is a residential street. There are only two forms of streets in the code. You're either a commercial street or a residential street. If there's to be more street types, let's add them in and modify the code. And Mr. Owens goes on in his report to say that it's hard to see how regular parking within the buffer complies with the stated intent of the buffer requirement. How can you screen something if you're actually doing it? Is it your professional opinion that the current buffer at Green Life that is at Maxwell Street does not meet the intent of a buffer between a commercial property and a residential property?
I want very much to give you a yes or no answer to that, but I'm finding it difficult. I don't think it meets the intent of the ordinance in the sense, just for the reason that was just mentioned. The truck, when it is in normal operation, is sitting in the buffer area.
The structure, if we were to build a new grocery store on that location, so it's non-conforming, it did not have a continuous use that would not have made the loading dock go to the other side of the building. And all this other stuff is dancing around the fact that the loading dock should have been somewhere else. It would never have been approved without having space for the adequate buffer to do what it needs to do. And the loading dock on the side of the street that must have trucks.
Understand why we have to have a timeline?
Because what we noticed on Target, how long it took, and some of the conversations we've had with Staples about they can't get to it because it's a busy time of year.
If I may finish, I don't see why we need to have a timeline. I think we made it very clear to our staff that we're serious about enforcement. They've said they're going to treat us seriously, and we have to nitpick them to death on every little detail that comes our way. That means they're not following policy guidance, and we need to address that instead of hammering on them with those kinds of details.
Mr.
Our code is fairly specific in terms of timelines for compliance with respect to notices of violation, and my suggestion is that we just follow that code instead of...
Works for me. That's great. Thank you.
Article 18, Enforcement, Section 7-18-1, Duties regarding enforcement. Unless specifically set forth otherwise in this chapter, the City of Asheville Planning and Development Director is hereby authorized to enforce the provisions of this chapter. The Planning and Development Director may enter any building, structure, or premises as provided by law to perform any duty imposed upon him or her by this chapter. Ordinance number 23691, 527 of 97. Section 7-18-3, Notice of Violation and Citation Procedure. A. Notice required before penalty. No penalty shall be assessed pursuant to Section 7-18-2 above unless and until the person alleged to be in violation has been notified of the violation in accordance with this section. B. Notice of violation, opportunity to cure. 1. Recipient of notice of violation. Whenever any city official charged with the duty of enforcing regulations in this chapter has reasonable cause to believe that a person is violating any of the provisions of this chapter or any permit, plan, order, or condition issued pursuant to this chapter, that official shall notify that person of the violation. If the violator cannot be ascertained, then the notice of violation shall be sent to the record owner of the land on which the violation occurs. 2. Service requirements. Notices of violation shall be in writing and shall be served by personal delivery or by certified or registered mail, return receipt requested. In addition, service hereunder may be made in accordance with Rule 4 of the North Carolina Rules of Civil Procedure. The notice of violation may include but not be limited to an order to discontinue the illegal use of land, buildings or structures, require removal of illegal buildings, structures, or uses, or prevent violation of this chapter. The notice of violation shall include an opportunity to cure the violation within a prescribed period of time. 3. Notification of owner upon violator noncompliance. Where the person violating a provision of this ordinance is not the owner of the property, and said violator has been notified and fails to respond to the notices within the prescribed period set forth in the notice of violation, then the city official charged with enforcing regulations in this chapter shall notify the record owner of land of said violation in accordance with subsection 2 above. C. Extension of time to cure. Upon receipt of a written request from the alleged violator or the property owner for an extension of time to cure or correct the violation, the city official charged with the duty of enforcing the regulations being violated may grant a single extension of time not to exceed a period of 30 days, in which the alleged violator may cure or correct the violation.
So I doubt they'll ticket this. They have yet to do it. But they've come out and they've moved this sign and they've ticketed my vehicle. I want to know how they can enforce this and not enforce this.
After being given a notice of violation pursuant to subsection 7-18-3B above, does not comply with...
Thank you.
I am too low on the totem pole to help you with a political situation.
Okay, well that's what I wanted.
Well, you got a ticket. So I'm sorry, but that's what I had to do because you're parking in the no parking zone.
But all this other doesn't apply.
I read you the letter. You have a copy of it because it has your name on it.
Okay.
Requested. In addition, service hereunder may be made in accordance with Rule 4 of the North Carolina Rules of Civil Procedure. If the violator cannot be ascertained, then the citation shall be served upon the record owner of the land on which the violation occurs. The citation shall specify the amount of any civil penalty which shall be levied against the alleged violator, or the type of criminal penalty applicable. The civil penalty shall be paid, or the violation shall be cured or corrected within 72 hours of receipt of the citation by the alleged violator or property owner, or such other time period not to exceed 30 days as the citation may specify.